Good morning, everyone, and welcome to this 36th Manthan series, Valuation Manthan series. And today we are going to discuss the valuation of the patents. And friends, on this December, I wish you all the very best and forthcoming year 2000. Good morning, everyone, also. And welcome to this lot of things are changing in the valuation Manthan series. So we have our ICAI valuation standards, we have international valuation standards, and the members have to mandatorily follow, who are registered with ICIRVO, to follow this institute's valuation standards. However, we have also made a comparison between ICI valuation standard and international valuation standards, and very soon we are also coming out with the valuation of standards of plant and machinery, land and building also. And our ICI RVO is also now recognized and registered for the that also, which was earlier only for the financial assets. And today we will be discussing the valuation of patents, where we have with us Yogesh Chatwani ji, who hails from Ahmedabad, Gujarat, and will share his knowledge. He is also the registered valuer. He'll share his knowledge across these patents, and Shruti will coordinate the session. If you have any question, please put it in the chat box. So at the end of the session, Yogesh Bhai will run through all the questions. I'm sure the deliberation which will be making, Yogesh Bhai will be making, all the questions will be answered in his deliberation only. And with these words, I once again welcome all of you on this Sunday winter morning and wish you a very, very happy session. Thank you very much. And stay in touch, stay connected with ICAI Valuation Standard Board. It is our endeavor to serve you the best. And this is how we are organizing this Valuation Manthan series. Once again, I welcome all of you. Over to Shruti.
Thank you so much, ma'am, for guiding us in the right direction and for sharing your opening remarks. So good morning, everyone. I am CA Shruti Gupta, moderator for 36th Valuation Manthan session, Valuation of Patents, organized by the Valuation Standard Board of ICAI. We are delighted to welcome you all to an empowering journey through valuation expertise. So moving forward without any delay, I am delighted to welcome our speaker, CMA Yogesh Chatwani ji. Thank you so much, sir, for being here and for sharing your wisdom with us. We are eager to learn from you. Sir is a registered valuer and an insolvency professional and a social auditor. Sir, you have a rich experience of more than 38 years in the field of finance and indirect taxation. You superannuated as a chief manager of finance from Indian Oil Corporations Limited in June 2021. Post that, you have continued your journey as a registered valuer and insolvency professional and a social auditor. You are also a faculty with various registered valuer organizations, IPA and ICAI. You have delivered over 1100 hours of virtual and physical sessions covering a wide range of topics, including valuation, indirect taxation, insolvency, bankruptcy law, general and business law, social audit, and macroeconomics. So, with such vast experience and knowledge, we are sure then that in the next upcoming hours, you will share with us immense insights and knowledge. We are all eager to learn from you. Over to you, sir.
Thank you, Shruti, CA Shruti, for giving that introduction. First of all, I would like to compliment each one of you for joining this virtual session. Today is Sunday, and Sunday normally we reserve for ourselves, for our family. But this shows your commitment for joining this particular session on Sunday. As we all are aware, there are no boundaries to learning actually. In my life, I have adopted the philosophy of lifelong learning. Learning never ends. And I am actually a very thankful and I am a very actually impressed by the way this evaluation standard board, ICAI evaluation standard board, they take a keen interest in arranging this session, and this session will go a long way in actually enhancing the knowledge of the members. And we all are professional, so we get opportunity to actually knowledge sharing through this session. We update our knowledge, we revise whatever we have learned so far. So these session in that directions are very helpful. Many times we feel actually I am already aware about a particular topic, what why I should join. But actually there is no limits, there are no boundaries to fresh learning. Even if we get 10 to 20% value addition through this type of session, so that will go a very long way. Now, I will actually fail in my duty if I am not expressing my sincere thanks to CA Hansraj Chubji, Chairman of Valuation Standard Board, CA Preeti Savla Madam, Vice Chairperson of Valuation Standard Board, and CA Joy Jain, CA Rahul, CA Dimple, CA Shruti, who have taken active interest in organizing this event and in arranging this session. So today's topic, which is given to me, is evaluation of patents. Now, we all are aware about the importance of intangible asset because the patents are a part of intellectual property, and intellectual property is part of intangible asset. So, going by the findings of a recently concluded survey, so on a global actually arena, around two-thirds of the value of the intangible asset that is not part of the financial statement. As we all are aware, going by the guidance provided under the financial statement reporting standard or a framework, whether that is IFRS or Ind AS, the internally generated intangible asset or homegrown intangible asset that is not reported in the financial statement. So, a modern days company, as we all are aware, these companies are asset lean company. So they have a very lean base of tangible asset, and mainly they derive a value from their intangibles. The companies like IT companies dealing in pharmaceutical or various other arena. So we are going to deliberate the importance of evaluation of intangible with particular reference to the evaluation of patent. So with that brief background, I would actually like to share my PPT. So just allow me 1 minute. So I hope my PPT is visible to each one of you. If you face any issue in visibility, please inform me anytime. Number one. Number two, make this session as a knowledge sharing session. After all, we all are experienced professional, and practically we learn from each other every day. So if you intend to share any of your knowledge through your experience on this particular topic, so you are welcome to do so. You may actually highlight that in the chat box, and same time if you have any query, so you may ask questions anytime through the chat box. Shruti madam will actually take those questions at the end of this session. Knowledge sharing and the interactive session are always in a mutual benefit. So with that, we will go to evaluation of patent, and this is the proposed coverage of my today's topic. Preliminary, we will start with a certain preliminary aspect of evaluation of patent. Then we will go through the statutory provision. As we all are aware, the patent rights are granted under the statutory provision under the patent law. So, for the purpose of valuation, very important to go through the relevant statutory provisions, and then we will go to a certain aspect of patent valuation. You will appreciate that this particular topic is having a very wide coverage, and in a session limited to just 120 minutes or so, I may not be able to highlight each and every intricacy, each and every aspect of valuation of a patent. But given that limitation, I will try my level best to give as much input as possible on this particular topic. So we will start with actually knowing a certain information. Somebody has rightly said, if you want to play a game, you first thing you need to do is to know the rules of the game. So actually, how the valuation of intangible. So overall, actually, asset class is intangible. So how it is important. So in that respect, I have taken out certain information which will highlight what is happening globally on this particular field. And in this consulting firm, Brand Finance PLC, so they are providing a very vital information. All this information is available on internet on a public domain. So here in this is actually the highlighting the global value composition trend in a US dollar, trillion US dollar. So here we will get the information about the tangible net asset, disclosed intangible asset, disclosed on the balance sheet. So as we all are aware, acquired intangible asset, these are reported on the financial statement. And disclose goodwill. Goodwill, as we all are aware, that is residual value during the process of PPA, purchase price allocation. And then we will go to what is the estimated value of the intangible asset, which is not part of the financial statement, or undisclosed value of the financial statement. So as you can see, this graph or chart will provide you the information starting with 1996, ending at 2023. So very recent. And as you can see globally, the value of undisclosed intangible, that is around 46 trillion US dollar. So you will appreciate that this is a very high value. The disclosed value of tangible asset, that is around 62 trillion US dollar, whereas the value of intangible, that is undisclosed on the financial statement, so that is around 47 trillion US dollar. And of course, this information is related to the public company, means mainly a public company. Private company information, as we all are aware, even if it is available, so degree of accuracy of that will always be a matter of speculation. So this mainly related to the listed entity across the world. So that is about the composition, value composition, and these are the sector. So in from the perspective of valuation, it is very important to know exactly which sectors are actually generating the intangible, and what is the share of undisclosed value of intangible. So as we can see, the internet and software, that is having as high as 81 percentage of intangible sector, undisclosed intangible. So that is actually having the highest value, internet and software. So as we all are aware, in the internet and software sector, they will need a very low value tangible asset, and mainly they will derive a value through their intangible. So only 10% value is derived through tangible net asset, which are reflected on their financial statement, and around 81% is the undisclosed value. So this is the sector-wise scenario. Household product around 70 percentage, cosmetics and personal care around 70 percentage, drinks 62 percentage, pharmaceutical 64 percentage. So this will give you an idea. Aerospace and defense around 59 percentage. So that is actually when we are dealing with valuation of intangible. We need to appreciate this fact. Majority of the value or the high value intangibles are not part of financial statement. This is the most intangible market value composition in 2023. As you can see, India, so as high as nearly 60 percentage, as high as nearly 60 percentage, a value of intangible that is not part of the financial statement that represent undisclosed tangible. And out of remaining a 40 percentage, as you can see, we have a certain disclosed intangible and a disclosed goodwill. So these actually will give you an idea which are the markets which is generating the most undisclosed intangible, and India is one amongst those 20 markets. So very important. And these are the stock exchanges, which is we have our National Stock Exchange and the Bombay Stock Exchange. So on a National Stock Exchange, the total value of intangible in 2023, that is around 1.78 trillion US dollar, and Bombay Stock Exchange we have around 0.92, less than 1 trillion US dollar. So that is the total value of intangible which are reflected on the National Stock Exchange, NSE and BSE. And we have this most intangible stock exchange in the world. So in that also India is finding a place. Our both stock exchange, Bombay Stock Exchange and NSE, both are here. So as we can see, Bombay Stock Exchange, the highest value of intangible, not part of the financial statement. So this will give you a fair idea, actually, the importance of valuation of intangible, the importance of giving our attention to the intangible, because going forward, plenty of opportunity will be available in the field of valuation. How that will be, we will see that in a little while. And these are the actually top 10 intangible companies in the world. So you can have an idea about this. All this I have taken from the website of Brand Finance PLC, which is a major consultancy firm in intangible. And these are available. All this information is available on a public domain on internet. And every year, this company, Brand Finance, they come up with similar data. So you can see the value of intangible around 2,681 billion US dollar, and that has registered a growth of around 17 percentage as compared to 2022. So that is the firm Apple. So that is actually is having the highest value intangible in the world, and then it is Microsoft. So as you can see, either that is information technology sector or the petroleum sector. Particularly after a pandemic, as we all are aware, the impact of pandemic on the prices of the various petroleum products, crude oil. And apart from that, as we all are aware, we have ongoing war between Russia and Ukraine from last more than 3 years or more than 21 months now. And we have ongoing a war between Israel and Hamas from last more than 22 months now, or from last more than 2 months now. So one war is ongoing for more than 22 months now, and another more than 2 months now. And as we all are aware, Russia, that is the third biggest exporter of the various petroleum products, including crude oil and LPG or natural gas. And we have actually the Israel and Hamas, they are located very near to the major energy exporting Arab countries. So because of that, as we all are aware, the prices of crude oil across the world that has gone up, and the petroleum sector or the energy sector is beneficiary. So Saudi Aramco, that is number three. Then Alphabet, Amazon, Telsa are doing a very good on electrical front. So electrical vehicle front, as we all are aware. So these are the top 10 intangible. Now we will go through actually the annual report, relevant portion of the annual report of some company, some selected company. and we will start with the Microsoft annual report. So this is again a 10K filing in the US regulatory authority. So SEC, we call it. This will highlight what is the importance of patents. So we protect our intellectual property investment. As we all are aware, patents are part of intellectual property rights. So we protect our intellectual property investment in a variety of way, and we work actively in the US and internationally to ensure the enforcement of copyright, trademark, trade secret, and other protection that apply to our software and hardware product services, business plan, and branding. So we are a leader among a technology company in pursuing the patent and currently have a portfolio of over 70,000, as high as 70,000 US and international patent. So as we all are aware, patents can be granted, means patent rights can be protected in a particular country, or that can happen internationally also at a global level. So 70,000 US and international patent, and over 19,000 pending worldwide. So this will highlight actually how the patent rights are obtained by the company, this Microsoft, and why we employ much of our internally developed intellectual property in our product and services. We also engage in outbound licensing of a specific patented technology. So patented technology that can be taken on a licensing also, so that we will go through, and that are incorporated in our license product. So from time to time, we entered into broader cross license agreement with other technology company covering entire groups of patent. So we may also purchase or license the technology that we incorporate into our product and services. So this will give you an idea how this actually a patent rights can be given on a license, or that can actually be purchased also. Entire a company, so that will be a with patent, so that will give the technology right. So we may also purchase or license the technology that we incorporate in our product and services, and at times we make select intellectual property broadly available at no or low cost to achieve a strategic objective like promoting industry standard, advancing interoperability, supporting social or environmental efforts. So that will actually give you an idea about the importance of patent right. This is actually from the Apple annual report of 2023, and this I am highlighting. Actually, we may obtain the patent. One inventor may obtain the patent rights, but ultimate beneficial economic benefit will come out of how those patent rights are protected. We all are aware actually. The author of a book may take the copyright, but in this era of means social various social avenues which are available. Those actually means PDF version of that will be available through WhatsApp or Facebook. So in that actually very difficult infringement of intellectual property that is very high. That is what is reflected here. So company currently holds a significant number of patent, trademark, and copyright, and has registered and applied to register additional patent, trademark, and copyright. So in contrast, many a company competitor seek to compete primarily through aggressive pricing and very low cost structure, and imitating the company's product and infringing on its intellectual property. So this is very important. Effective intellectual property protection is not consistently available in every country in which company operates. So from the perspective of valuation, this is very important because ultimately what is valuation? That is estimation. Estimation will depend on certain assumption and a certain projection. We may actually make certain projection, actually assuming that the IPR will be protected, but if it is not happening, So in that case, what will happen? Whatever estimates are there that we made as a valuer, that may not hold true. So actual results may actually vary significantly as compared to the estimated value done by a valuer. So we keep this consideration actually while making a valuation. Even a company like Apple, which is having global presence, they actually highlight the fact that effective intellectual property protection that is not consistently available in every country in which the company operates. And if the company is unable to continue to develop and sell innovative new product with attractive margin, or if competitor infringe on a company's intellectual property, the company's ability to maintain a competitive advantage could be materially adversely affected. So this is actually from the management commentary, which is provided to the shareholder as part of the annual report. So that is from Apple. Moving forward, Amazon. So how actually legally it is dealt with. So that is highlighted here. So in October 2020, this particular TV, Broadband TV Inc., filed a complaint against Amazon.com Services LLC and Amazon Web Services in the United States District Court for a Western District of Texas. So complaint alleges, among other things, that certain Amazon Prime Video feature, so that is actually entitled so and so. So we will not go into a detail of that. But the complainant seeks unspecified amount of damages, and in April 2020, this TV alleged in its damage report that in the event of a finding liability, Amazon could subject to around 166 to 986 million US dollar in damages. So that will highlight wherever actually the infringement is there, alleged infringement is there. So what value is involved in that, that you will appreciate from this figure, around 166 to 986 million US dollar. So that is the quantum of a legal suit. And this is from TCS, this is Indian company, and that is actually one amongst the 100 company which are part of this report. That is uh, TCS continues to contribute to standard in arena like environmental engineering, cyber security, cyber reliance, and companies' intellectual property that grew with 260 plus publication and a presentation in top tier general and conferences. So as of 31st March, 7,305 patents have been actually filed by the company, and 2,878 have been granted. So that is actually a future course of action which is proposed by TCS. That is, a company will continue to scale patents, products, platform strategy across the organization. So that is actually the future strategy. So these information will highlight the quantum of patent, number one, and number two, there is less, means there are always possibility of infringement of the intellectual property, and what are the quantum of lawsuit, what damages, quantum, the amount of damages are involved in that. So that we will get information from this. And this is actually again findings of a survey. This is on S&P 500 market value, component of S&P 500 market value in USA, which are listed on S&P stock exchange in USA. As we can see, in 1975, the total market value of this S&P 500 company, that was derived 17 percentage only out of intangible, and remaining 83 percentage value that came from the tangible asset. And come to 2020, so around 90 percentage value that is from intangible, and only a 10 is from a tangible asset. So this will highlight the importance of a tangible. Now we have covered enough and about this information. And now we will go to this IASB research project pipeline. So actually, this is with reference to, as I informed you, the internally generated intangible or homegrown intangible that is not part of the financial statement. So actually, many experts now say it is time to go tangible about intangible, meaning that actually some type of guidance is required within the framework of accounting standard, so that the information relating to undisclosed intangible that is provided to the all stakeholder. So that is the need which is highlighted from time to time. And finally, the International Accounting Standard Board, they have actually kept this project in their pipeline, this research project in their pipeline. So I will only highlight the important portion of that. So IASB acknowledges that comprehensive review of IAS 38 will be a large and complex project for IASB and its stakeholder. So to make such a large project more manageable and to allow more timely progress, this project could be undertaken in stages. So, for example, such stage could comprise the development of enhanced disclosure requirement, including a disclosure about unrecognized intangible asset. So, at present, if we review the financial statement, we may not get the information about the undisclosed or unrecognized intangible asset. So now actually IASB, they are actually seriously thinking of providing information about unrecognized intangible, maybe by way of disclosure to the financial statement of a company. So in that actually, this actually will provide you insight going forward. Actually, this will enhance the requirement once it is part of disclosure. So you all will appreciate that whatever value estimations are there of undisclosed intangible, that will actually have a very huge task, and that can open up plenty of opportunities. So that I need to highlight. And a review of scope of IAS 38 to consider whether some recognized intangible, including intangible held for investment purpose or traded like crypto, that should remain within the scope of IAS. And a review of the definition of an intangible asset and a recognition criteria, and a review of measurement requirement for intangible asset within the scope of IAS 38. So all these developments are happening actually, and going forward, we may actually have a plenty of opportunity for evaluation of unrecognized intangible. So that will give you an idea. Moving forward, we will go to the introduction of intangible. So as we all are aware, intangible we can divide majorly into three category, three types. So rights, relationship, and intellectual property. So this is the broad category under which all intangibles are incorporated, are part of these three category, all intangible. So that is actually legal rights and privileges. What is right? So that is legal rights and privilege that confer the competitive advantage. And we can have example of that: lease agreement, distribution agreement, the convents may be applicable to the intangible as well as a tangible or a financial asset, then a supply contract, franchisee agreement, and evaluation will involve assessment exclusively and enforceability of these rights. So that is the relating to rights. Relationship, so that is strategic and contractual relationship. An example of that will be customer relationship, distribution agreement, strategic alliances. Intellectual property, so our today's topic, patent is part of that. So creation of mind that have a commercial value and are protectable by law. So very important. Number one, it is creation of mind. Number two, it has a certain commercial value. So without commercial value, all intellectual property will be useless. So very important to have certain commercial value, certain economic value. Assets, as we all are aware, that is nothing but resources to generate a future economic benefit. So if intellectual property fail to generate the commercial value or economic value, that is a useless, that is a valueless. So that is again a very important, that need to be protected by law. So if protection is not provided, so that may actually have less value or no value perhaps, and encompasses a patent, trademark, copyright, trade secret, a proprietary technology. So all these are part of IPR or intellectual property, and valuation will be these actually very critical. So that we need understanding of the uniqueness and market relevance of the IP. So here, these are the key consideration in evaluation. A synergy between these components will often amplify overall intangible value. So as we all are aware, there is synergy between various intangible, and that makes measurement difficult. Exact value of a different intangible, very challenging, very difficult, and that is how that is not reported in the financial statement. And intangible contribute significantly to a company's competitive position and market capitalization. So how it is contributing to market capitalization of a company, we have seen in the previous slide. And accurate valuation, that is crucial for strategic decision making, financial reporting, and a transactional purpose. So that is about the introduction. And now, actually, we have three types of intangible: right, relationship, and intellectual property. So we will now move to the intellectual property, because a patent is a part of the intellectual property. So these are the dynamics of intellectual property asset. IP asset within the intangible landscape. So, as we covered in the previous slide, so IP asset is form a distinctive subset of a broader category of the intangible asset, and their uniqueness lie in being creation of law. So that is actually, as we all are aware, patents are created through statutory provision. The Patent Act of 1970 in India, setting them apart by legal protection and enforceability. So IP asset, including a patent, industrial design, a trademark, copyright, trade secret, benefit from explicit legal protection. Very important to have the explicit legal protection. Otherwise, as we discussed, the intangible may become a valueless. So that is very important to have actually the legal protection. And notably, they are independently identifiable. So unless it is identifiable. So these are the characteristics which are needed for recognition of a intangible. So these are independently identifiable, transferable, and purchase an economic life, differentiating them from a longer legal lifespan. So a very important, the economic life of a intangible, that can be different from the legal lifespan. So under actually provisions,
Recording
very
in
important
progress.
characteristic which are required through the statutory provision: novelty of idea and the originality. So unless it is original, patent rights cannot be granted. So these legal framework establish the foundation for recognizing and safeguarding various forms of IP. So these are the qualitative standard from a legal perspective and economic dimension of IP asset. So we discussed about that. Shifting to an economic perspective, a value of IP is intricately linked to its economic benefit. So unless there are economic benefit, no asset is useful, whether that is tangible or intangible, and that is applicable to IP asset also. So a patent's economic value is contingent to its contribution to income, a production, or a protection. So very important. Supposing I have created a new product, a novel product, but unless that is accepted by the customer, so ultimately I should derive some economic benefit out of that. So I have obtained the patent for a new product, but unless that is sold, that new product is accepted by the customers, that product is actually getting a sales volume in the market, so that may not have economic value and that will be useless. So very important, a patent economic value that is contingent on its contribution to income production. So though patent is a tangible, so its value will be derived from, though patent is a intangible, as we all are aware, patent is intangible. But value of that will be derived from the tangible benefit. So that is the relation between intangible and tangible for the perspective of patent. Patent is intangible, but its value will be derived through a tangible benefit. So that is a very important. An IP asset may have a legal existence. Its economic value is contingent upon its tangible impact, as we discussed, on income generation or a protection. So this distinction that is crucial in the valuation process, and that will emphasize the practical significance over mere legal recognition. So very important. There need to be practical significance rather than having merely the legal protection or a legal recognition. So, a valuation professional will play a pivotal role in bridging the legal and economic dimension of IP asset. So, that is the role of valuation professional to bridge the gap between a legal and economic dimension and accurate evaluation that will enable informed decision making in transaction. Licensing, because patents can be given on a license also, and strategic business endeavors. So that is a very important. These are the dynamics of intellectual property asset. So why actually we need the evaluation of intellectual property? These are a certain area which I have highlighted. This is not exhaustive. This is just for illustrative purpose. So we need the IP valuation for strategic decision making. Maybe actually the means IP assets, particularly the internally generated IP assets that are not part of the financial statement, but management will always require the value of intangible so as to make the strategic decision. Like if a company is having a patent rights, so company will always have a value of that with reference to operating either in one region of a country or multiple region of a country or in multiple countries. So that will actually, the valuation will be very handy in making such a strategic decision. Valuation that is crucial for a strategic decision making, and that will guide the company in making assessment of the worth of their patent, copyright, trademark, and trade secret. Financial reporting. So as we all are aware, going by the guidance provided in a financial reporting, there are various events in which we need the evaluation of intangible, like for the purpose of the means impairment testing, for the purpose of impairment testing, or for the purpose of purchase price allocation. So these are the two events, for example, which actually will need a valuation of IP for the purpose of financial reporting. So understanding the value of intellectual property for the transaction like purchase price allocation or impairment testing, that is essential for accurate financial reporting, and that will influence the balance sheet and overall company valuation. Merger and acquisition, we discussed actually, that will the evaluation of IP will actually help in a finalization of deal price. So amended transaction, as we all are aware, these are high value transaction, and particularly the companies who are dealing in fields like IT and all. So they will derive a very less value from their tangible, and a majority of their value that will be derived out of intangible. So very important to have a valuation of intangible in amended transaction. That will play a pivotal role in the determination of the overall deal value and negotiating the favorable terms. Licensing and royalty. As we discussed, this patent can be given on a license also. So that will require the evaluation. That will be instrumental in making in establishing a fair licensing agreement and a determination of the appropriate royalty rate, and that will ensure a balanced and profitable arrangement. Risk management, again, very important. So making assessment of the value of intellectual property that will help in a risk management by identification of the potential risk and opportunity which are associated with the IPS. So that is the importance. Apart from that, for a capital investment decision, so company will rely on IP valuation when making decision about investing in a development, acquisition, divestment of intellectual property, litigation and a dispute resolution. So we have seen actually in the previous slide about the litigation, which actually ongoing in case of Amazon. So that was just one case I had highlighted. If you refer to the annual report of the Amazon, you will come across many more such lawsuit which are ongoing for the company. So a valuation of IP that will be very critical in providing the basis for a damage calculation and a settlement in a case of IP infringement or the dispute. Taxation a consideration, again a very important field. So IP valuation will influence the tax assessment, and that will affect the taxable income of company, particularly in a jurisdiction where intellectual property is considered as a taxable asset. Investor confidence, so accurate IP valuation that will enhance the investor confidence by providing transparent insight into intangible assets of a company. So, securing finance. So, as we all are aware, in India, the public sector bank they avoid giving a finance based on intangible, particularly after what happened in case of a Kingfisher airline. So, you all may be aware about the Kingfisher Airline, how company failed to make repayment of a high value loan which company had borrowed from the commercial banks in India, and a very large portion of those loans were actually given by the commercial banks based on the brand value of the Kingfisher Airline. So we all are aware if a company fails, there will not be any brand value attached to that company. And ultimately, what security was offered by the company that became useless. So securing financing, again, a very important. So unless there is a reliable valuation, that means of securing financing will be very difficult. Probably the public sector bank or commercial bank they are not giving finance, but private capital is always available for giving the finance. So in that direction also a very important to have a valuation of IP, and that will be pivotal in securing financing, like lenders and investor often consider a value of intellectual property when making evaluation of the overall collateral and a worthiness of a business. So that is the importance of IP valuation. As I informed you, this is just illustrative in nature, not exhaustive list. You may have many more instances which will reflect the importance of IP evaluation. So, a strategic decision making, a financial reporting, M&A transaction, licensing, royalty, risk management, capital investment decision, litigation and dispute resolution. All these are events, circumstances, situation, scenario where evaluation of IP or intellectual property that will have high importance. So actually, a technology. Apart from that, we can have for the purpose of technology transfer. So university, research institution, business, they engage in a technology transfer where IP valuation is essential. Brand management. So valuing trademark and brand related IP that will help in effective brand management. Economic contribution. So actually, incidentally, I recall this brand finance. A PLC, which is a consultancy firm. So if you actually are interested in getting the information about brand value of a company, brand value of a celebrity like Virat Kohli and all, so you may visit the website of this brand finance ILC, and you will get estimate of brand value of various companies in India. So there is a India specific report. So companies, celebrities, value estimation you will get from a website of brand finance. So economic contribution, intellectual property will often make significant economic contribution, and understanding its value of contributes to a comprehensive assessment. So these are the certain area which will highlight the importance of valuation. So ultimate aim of any patent holder, any holder of the intellectual property right, their actually ultimate aim, ultimate objective will to maximize the value from intellectual property. So how that can be done? So there are three avenues which are available. So direct exploitation of IP. So companies or patent holder or IP holder, they can realize value through direct utilization of IP, like incorporating patented technology into product. We all are aware how the patented product or the branded product, they command the pricing premium. So they may actually have a valuation out of that. They may derive economic advantage, economic profit out of that. So strategy may include incorporating patented technology into product, processes, or services. That is direct exploitation by the patent holder. Then a sale or licensing strategies. So I highlighted that in the annual reports of leading intangible assets holder company like Amazon and all. So they unlock value by strategically selling or licensing the IP to the third party, and licensing agreement that can generate revenue stream, while selling IP outright that can result in immediate financial gain. And these are the two avenue, either direct exploitation or a sale or a licensing. But even through non-exploitative value addition, so even there are non-exploitative value addition opportunities. So even without direct exploitation, ownership of an IP that can contribute a value through strategic maneuvers. So these are the five factors of Porter's analysis. As we all are aware, evaluation that is actually having a two major factor. Number one, qualitative and quantitative. So in qualitative factor, we all are aware about theory of five factor theory of Porter, which is developed by Mr. Porter. So minimizing the negotiating power, offsetting supplier power, mitigating rivalry, raising barriers to entry, reducing a threat of substitute. So all these are actually from the perspective of non-exploitative value addition. So I hope this will give you an idea how actually or what consideration we need to keep in mind while making evaluation of intellectual property. Before we go to specific of the patent, I would like to highlight this quote, and this quote is as old as of 1851. We are in 2023. So if you refer to economics of July 27, 1851, you will come across this quote, famous quote: patents are like lottery in which there are a few prizes and great many blanks. So that is very important. Actually, if you see, actually, if you keep the value of patent on a bell cow, you all are familiar with the bell cow. So that is skewed right in case of value of patent. So that is skewed to its right to the bell cow. So that is not even. So patents are like lottery in which there are a few prizes. So some patents will become a very high value, some will generate a very high economic value, some may actually have a very less value or no value at all, and that will depend on the acceptance by the customer. We can compare that with a startup entity. So as we all are aware, startup will come with some new idea, novel idea, some innovation in product, some differentiation in product and services which are offered at present. So the actually, but ultimately, I may come up with any idea, but ultimately that need to be accepted by the consumer, with the customer of that product, or the services. So I may actually provide any service, I may offer any product in the market, but ultimately that should be useful, that should be capable of generating a certain economic benefit. And that is the reason, as we all are aware, around 90% of the startup entity, they fail, and only a 10% of the startup entity, so they actually go means achieve greater heights. They actually have a very high valuation. Acceptability of those 10% startup, that is very high, and they generate huge value out of their novel idea. So same thing is applicable to patent. Many patent may become worthless, and only a few will have the prize. That is like a lottery. So this aspect also we need to consider in evaluation, because we may come out with a very high valuation estimate, but ultimately what is needed is how accurate that valuation as compared to the actual result. That is very important. So I hope you are finding this useful, and I will request Dimple ji, Dimple, CA Dimple, if you have actually, if you get any feedback, about the change in my way of presentation, so you may do so. Just give me a minute. So we all are aware, in actually each country, they have their own intellectual property offices located at various places. So as we all are aware, in India also, we have the intellectual property offices which are located in major metros in the like Bombay or Mumbai, or the Chennai or Kolkata or Delhi, etc. So likewise, actually, all these intellectual property offices across the world, that is managed, actually, that is under the World Intellectual Property Office. We call that as WIPO. Traditionally, in the field of patent, actually, China, that is having a very high number of patent as a country, followed by USA and various European countries. So traditionally, India was not even actually in the major 20 countries, I will say. But of late, actually, in India, the more and more number of patent applications are filed. So that is reflected in this particular report. So first, the good news: innovator around the world submitted nearly 3.5 million patent application last year. So this report is of 2023, and here it is. Numbers are relating to 2022. 3.5 million patent application which were filed by the innovator across the world. And what is notable is the broad geographical base of this growth. And among top five offices, patent application at both IP Office of China and European Patent Office that outstrip the global average. So that is the actually China and European countries, and with the US returning to growth for a first time since the pandemic. So that, as I highlighted, China, US, and European countries, they are the major player. Broaden the lens to the top 20 offices, and we see a double digit increase at the offices of South Africa, India, and Indonesia. And for India, this is the sixth year of growth in a row, with patent filing surging by a quarter last year in 2022, the fastest increase since 2005. So of late, as we all are aware, Government of India that is providing encouragement on various research and development activity, and they are encouraging the innovators or the actually means whoever is making new invention to file their patent and get the overall protection through a law. So that is a very much important, and that is highlighted here also. A sixth year of growth in a row with patent filing surging by a quarter last year. And although patent can be maintained for up to 20 years, the average age of patent vary across the offices. And among the selected 20 offices reported in a figure, the average age of patent in a force in 2022, that was 11.6 year in Brazil, down to 6.8 years in Monaco, and patents in force in India, that is 11.4 year. So whenever actually we are deriving a value of a patent, so we need to estimate the economic life. As we all are aware, globally recognized, there are three approaches to evaluation: cost approach, market approach, and the income approach. So when we are doing the evaluation under income approach, and going forward, we will learn in this session a key income approach that is widely used for evaluation of intangible. So when we are going by the income approach, particularly the discounted cash flow method, so in that actually we need to have a projection about a future case inflow. Now, the life of the patent, as per legal provision, as per provisions of Indian Patent Act, or that way across the world, that is 20 year at present. But actually, that is not the economic life. So actually, a question will come: what the total economic life need to be considered? Because as we all are aware, we are living in the era of technological upgradation, and the degree of technological upgradation at present, that is much more as compared to a 5 year back. So in that scenario, I may come out with a novel idea, but my competitor, if they find actually my product as useful, having high consumer demand, so they may come out with the alternate product with slight modification. So because of that, actually, over a period of time, my actually novel product may no longer remain as a novel product, and that will actually impact the value of a product. So a very important, very critical consideration in evaluation is to estimate the economic life. So here we will get a threshold, here a benchmark in India. The economic life of patent, that is 11.4 year. So that is the upper limit, and within that, based on the ground reality of each assignment, we need to estimate the economic life. So that is very useful in ascertaining the economic life of patent. Now, this is actually the trends in a patent application, and this I have taken from the annual report, which is published by the Indian Intellectual Office, Intellectual Office in India. You can see here, so how actually this will highlight the number of application or the trend in a patent application. So that we have seen in the previous slide also. So in 2017-18, the number of applications filed were 47.85, 47 lakh 85,000. These figures are in thousands, so number of application in thousands. So that was around 47 lakh 85,000 number of application filed in 2017-18, and that has gone up to around 66 lakh 44,000 in 2021. And out of that, this is the process once patent application is filed. So that will be examined by the patent office. Finally, the patent rights will be granted, and some application may not actually get the patent right, and they will be disposed of. So this will highlight actually the in 21 22, the number of applications filed were 66 lakh 44,000, out of which around 60 lakh 57,000 applications have been examined. So you can see now the process of examination that is very fast in India. Concurrently, actually, same year, the application filed are examined, which was not the trend in the past. And out of that, actually, patent rights are finally granted for around 30 lakh 7,000 applications in 21-22, and around 35 lakh 99,000 applications have been disposed of. So a difference of this, 35 and 30, those in other words, patents have not been granted. So that is actually give you some idea about the numbers. So this is trend of patent application, and this is actually a trend of a trademark. So we will not go into details of trademark, which is not related. And this is the legal framework in India related to intellectual property right. We have the Patent Act of 1970, Designs Act of 2000, Trademark Act of 1999, a Geographical Indication of Goods Act of 1999. We all are aware certain products are given the GI tag. Once the GI tag will command the pricing premium, that actually will get not only a national recognition, the product which are having the GI tag, they will get the global recognition also. So, Geographical Indication of Goods Act, very important. Copyright Act, we all are aware about that. That is granted to the author or the means new idea, new creation. So, Copyright Act, a protection of integrated circuit layout and designs act, and a protection of plant varieties and farmer rights act. So this is the legal framework, and so if we deal with the patent, so that is very old. Actually, in 1856 also we had this protection available. So that was through Act 6 of 1856 on a protection of invention, and this was based on the British patent law of 1852, and a certain exclusive privileges were granted to inventor of a new manufacturer for a period of 14 years. So originally that was 14 years, but at present, as we discussed, the patent rights are granted for a period of 20 years from the date of filing of patent application with the patent office or with the intellectual property office. So this is the historical background. We will not go into detail of that, how it has progressed in 1859, 1872, 1883, 1888, 1911, 1999, 2002, and 2005. So that is actually the journey of patent law in India. Moving forward, That actually a present act is a Patent Act of 1970, and that is amended in 1999, 2002, and 2005. And a patent rules, so that is giving a certain formality how to file the uh, patent application, how actually what the process is involved in that. So we will get guidance on that from patent rules of 2003, which are again amended in 2005 and 2006. And this is the process in brief how actually patents are filed. So first actually is a patent search. If anybody has a certain novel idea or some novelty or new creation. So first thing is we need to ascertain whether for that any patents have been granted in the past actually. As you all may be aware, the patent office, they publish a weekly publication, a weekly magazine. So that actually what I will do, I will highlight that so that we can have an idea. So I will stop sharing this and I will share the new magazine so that you have a brief idea about that. So just allow me 1 minute. I hope my this screen is visible to each one of you. Actually, this
Yes, sir.
is the this is the actually official journal of patent office, which is published every week. So this is last journal, 15/12 2023. As you can see, this is having 696 pages. But this is part one. Like that, this journal is in a six part, so very voluminous document, and this is actually this. You can see this in view of the recent amendment made in Patent Acts of 1970. So that was effective from 1st of January 2005. The official journal of patent office is required to be published under the statute, and this per journal is published on a weekly basis on every Friday, covering a various proceeding on a patent as required according to a provisions of section 142. So very important, if you actually many times you may have a question from where I will get the information. So you can get this, and as you can see, these page numbers are highlighted, starting with 88 to 29. So these are pages numbered from 88,229. So that actually you need to refer all the general. So this will give you an idea how detailed this is, and this may give you an opportunity about a practice actually exclusively in a patent. So that is also very much available, and these are the offices of a patent, and this is actually how the patents are filed. So patent application, a publication, a date of filing the application, a publication date. We will go through this provision. These are the international classification. So classification in itself is a very big task, and who are the applicant? What is the process? So abstract of that is given. Presented invention provide a cost-effective and efficient solution that automatically stop the flow of IV fluid. So related to hospitals and doctors, IV fluid. Once the drip bottle is emptied, blood cell monitor. So like that, actually, you will get the detail about the various applications which have been filed with the patent office and their present status. So I hope that you will find this useful. You need to visit the website of Indian Patent Office for downloading this general wherever you need actually. And these are the general which are published on a weekly basis. So this patent search, this is the procedure. So a patent search. So how to make patent search? I have actually highlighted the relevant document for that. Then a filing of a patent application, publication of a application, and a patent objection and examination. So a public at large, they can raise the objection if any applications are filed, and if they feel this particular product that is already actually invented by me, or that I am already dealing in a provision of that services, or in selling that particular product. So any affected party, they can file an objection with the patent office. So that process also we will go through in brief, of filing of objection and examination, and finally it will be grant of a patent. So this is the entire process, and this actually entire procedure for a grant of a patent, starting with the filing of application, then actually what is the pre-grant opposition, what are the objection which are not complied within a 6 month re-examination, then actually we appeal to the adjudicating authority or the appellate authority, then how actually payment of fees, patent fees is paid, and how finally it is granted. So all this procedure in a brief, you will get through this flow chart that will give you an idea about entire process or a procedure, starting with the filing of application with the patent office till it is granted. So now we will go specific to the patents law in India, which is very important, because unless we know the statutory provision, as we all are aware, all type of valuation that will either related to the intangible which are created through statutory provision, or that will be internally generated. So patents, as we all are aware, that is created through a statutory provision. So very important to have idea about a basic idea about the statutory provision. So that we will do. Just give me a minute. So, what exactly is a patent? So, that is legal monopoly. As we all are aware, government will discourage the monopolistic condition in the interest of consumer at large, and government through a statutory provision have taken a very wide range of action to prevent the monopoly, because if there is a monopoly, as we all are aware, the affected party will be the consumer, and which may comprise of the general public or a weaker section of the society. So which may also comprise the weaker section of the society. So very important to avoid the monopolistic condition in the market. That is the prime objective of any government. But at the same time, government should also encourage the research and development activity. Otherwise, a company may not progress. So a very strategic balance. The government across the world, they need to maintain that is one side is a protection of the consumer interest at large, and on the other side the encouragement which need to be provided for novel idea, for research and development. So patent that will give the legal monopoly. So a patent will represent a legal monopoly which are granted by the government to inventors, and that will offer exclusive right to exploit their invention. As we discussed, exclusive right, so that will give the sole ownership. So patent holder will enjoy exclusive right, and that will prevent others from making, using, selling, or importing the patented invention without the permission. So we all are aware about actually a vaccination during the pandemic. So how companies obtain a patent for their new invention related to a vaccination during the COVID 2019, and how they enjoy or how they command the pricing premium, particularly the pharmaceutical company who invented in USA. So that actually about the ownership, patent holder will enjoy exclusive right, and that will prevent others making or using or selling or importing the patented invention without permission. And but that will be for a limited duration. So a patent will have a finite lifespan, typically 20 years from the filing date, and that will provide a temporary but not a powerful a competitive advantage. So that will provide a temporary but powerful competitive advantage. So typically it is 20 years, but there are a certain exception. There are a provision related to compulsory licensing after a certain period in the overall interest of the consumer. So that we will go through. And invention scope, so technical innovation. So patent will cover a novel and non-obvious technical innovation. So that is very important. Number one, the idea should be unique, idea should be new, idea should be novel, and that need to be non-obvious technical innovation. Non-obvious technical innovation, and that can range from a product or a processes to methods and a composition. So that will be pharmaceutical composition or any new product, any new good, any process which is part of the production, entire process of manufacturing, entire process of production. So anything actually that can be have the patent right, but provided it should have the commercial value, economic value. So novelty and non-obviousness, that is a patentable, and invention must be novel, not publicly disclosed before filing. So in that connection, I highlighted that a weekly journal published by the Intellectual Property Office, which will give you idea that publication is not only in India, but supposing you need to have idea about a patent right obtained in USA, so you need to refer to the journal which is published by the Intellectual Property Office in USA. So that is actually you will get publicly disclosed before filing and non-obvious inventive step beyond existing knowledge. So that is non-obvious. Now we will go to the valuation. So that is a patent type. Valuation will depend upon the patent type, the utility patent. So that will cover a functional invention, including machine, processes, composition, or matter. Design patent. So that will protect the ornamental design or appearance of an article, and applied patent, so that will be granted for invention or a discovery of a new plant variety. So that is actually separate law will deal with it. We will see to it. So we can have utility patent, design patent, or a plant patent. Now, as we all are aware, going by the provisions of the company's registered valuer and valuation law, a valuation that is divided into three asset class. We have the separate valuer for land and building, separate class of valuers for land and building, plant and machinery, and securities and a financial asset. So, SFA valuer, they are responsible for a valuation of intangible asset, including the patents. Now, actually, you all will appreciate whatever actually information we have till now. So, estimation, projection, that will actually necessitate the technical knowledge also. Supposing you are dealing with a valuation of a pharmaceutical composition, say the vaccination which is useful in COVID 2019. So you actually, we all are from finance background, but we are supposed to have the basic knowledge about the pharmaceutical composition, how actually that will create demand in the market, whether that will actually have a certain economic value or not. That judgment, because valuation is a judgmental, a valuation is a subjective. So valuer is supposed to have the technical knowledge, maybe basic technical background for a valuation of a patent. So in that direction, before we go forward, what I will do, I will like to highlight a patent valuation report so that you have an idea what details are reflected in the valuation report and how it is technical in nature. So again, I will stop sharing this and just give me a minute. I will share one particular valuation report to give you a practical idea. Theoretical, we can have a certain thing, but practical is always important. So this is the patent valuation report, and this is international patent publication. So this is actually relating to international patent protection. That is the international patent publication. We will go through more about this. And international patent application. The title is Watch. Applicant is Citizen Watch Company Limited. Inventors are so and so, and a filing date is so and so. Publication date is so and so. Priority date is so and so. So that is you can actually this is just a basic information, and a patent overview of IP valuation, a patent valuation approach, a valuation of patent application, and a valuation certificate. So a patent overview. So you can see this actually this means abstract this watch as a first device mechanism, including hand having a rotation axis extending in a first direction, a wheel work, a driving source, and a second drive mechanism. So you will appreciate that a patent will involve different sectors, different industry, IP, IT sector, the finance sector, the pharmaceutical sector, the watch, means, this consumer utility sector, products having consumer utility, FMCG, and all. So any type of product that can claim for a patent protection. So very important to have a basic idea of that. So here I am highlighting how we need to have a certain basic idea about how a watch is comprising, how it is functioning. So that will be very important. An assumption related to entry proposed in a product in Indian market. Then we have certain claims are made by the applicant. So claim one, a fast drive mechanism including pointer, a wheel train, and a drive source having rotation axis. So that actually wristwatch not actually so uncommon for all of us, but in that also this many claims are made. We will not go into detail of that. Claim 1, claim 2, claim 3. So as you can see, there are 13 claims which have been made. And this is the relevant drawing of the proposed inventive subject matter, a technology overview of IP valuation, what is the market size, and what is actually the annual growth rate of that particular product, market penetration. So all this is required, a detailed study is required, price per unit, profit margin, a technology readiness, tax consideration, and then actually a discounting a factor, very important in evaluation, and finally actually this value application. Now we may be efficient in crunching of this number, we may come out with the projection, but ultimately this projection need to be supported by certain reliable evidences, certain reliable information, certain reliable documents, and that will need the technical knowledge. And no one in this world will have actually knowledge of all the sector. So necessarily what I need to highlight is this is a teamwork. So patent valuation that will actually require an entire team consisting of the technical person, maybe outdoor or indoor, and the financial number valuation knowledge. So all that is very important. And how, as you can see, through with the aid of this drawings and all that is highlighted in the evaluation report. So this will give you a fair idea what I need to highlight. Actually, without the support of technical person, we may not be able to give a full justice to a valuation of any type of intangible, including the evaluation of patent. So these are utility patent, a design patent, a plant patent. So public disclosure, as we all are aware. So in exchange for exclusive right, patent holder must disclose their invention in a sufficient detail for others to replicate or understand. Commercial value, so asset with economic worth beyond legal protection. Patents are a valuable asset and that will contribute to a company's market position, innovation portfolio, revenue stream. So how that is important, we actually got an idea about the relevant portion of the annual report of the company, how they give importance to the intellectual property asset. So a strategic role. So all these are actually decoding the patent evaluation. Now this is the actually statutory definition, a meaning of what exactly is a patent. So that is actually highlighted in clause J of subsection 1 of section 2 of the Indian Patent Act of 1970. So what is the meaning of invention? As we all are aware, patent rights are granted for a new invention. So, what is the meaning of invention? Very important to know that. So, that means a new product or a process that will involve inventive step and capable of industrial application. So, as we discussed, unless it is capable of industrial application, unless it is having a certain economic value, unless it is having a certain commercial value, the patent rights cannot be granted. So very important to have a invention which is capable of industrial application. So therefore, any product like a device, machine, or composition, any process which is used for preparing a tangible product is patentable. And only if, but these are the condition, only if the product or process that is new or novel, that involve an inventive step that is non-obvious, as we already covered, and that is of industrial use. So that will highlight the aspect of usefulness. So what is not patentable in India? So very important. Again, this is illustrative. If you go through the provisions of Indian Patent Act of 1970, you will get a host of information which is non-patentable. So that you need to go through in a detail. But here I have highlighted a certain thing. So invention contrary to public order, morality, or health, that is not patentable. So any invention that is contrary to public order, morality, or health, that is not patentable. These include invention that promote immoral activity or that are harmful to the public health. So all those invention which are harmful to public health or that are immoral activity, so that is not patentable. Discovery, scientific theory, and mathematical method. So a discovery, a scientific theory, and mathematical method are not considered patentable. That will include law of nature, natural phenomena, or abstract idea. Then a plant and animal variety. So plant and animal variety are not considered patentable, but they can be protected under a separate law, as we have seen the legal framework in India in the previous slide. So that actually have one of these statutory law that is related to Plant Variety Protection and Farmer Rights Act of 2001. So any plant and animal variety that is not patentable under Indian Patent Act of 1970, that is patentable under the Plant Varieties Protection and Farmer Rights Act of 2001. Then we have the business method and a computer program. So any business method and a computer program, these are not considered patentable, although they may be protected under the copyright or other forms of intellectual property. A mere arrangement or a presentation of information. So a mere arrangement or a presentation of information, these are not considered patentable, although they may be protected under copyright or other forms of intellectual property. And a medical treatment. So methods of medical treatment are not considered patentable, although products and composition which are used in medical treatment, that may be a patentable. So this actually will give you an idea about what is not patentable in India. Again, this is not exhaustive list. This is illustrative list. For more detail, you may go through the relevant provision. Now, patentability criteria, these are the salient feature of a patent law in India. So, the criteria for obtaining a patent. So, Patent Act lays down specific criteria for patentability of an invention, which will include a novelty, inventive step, and industrial applicability. Invention must not have been disclosed in any publication. So, I have just given you idea about the publication, the magazine published by the patent office in any publication or used anywhere in the world before the date of filing of the patent application. So remember, anywhere in the world, not in India. So that is not means very important to get the patent. Types of patent. So Patent Act recognize mainly two type of patent: product patent and a process patent. So product patent cover a new product or a substances, and a process patent will cover a new methods of manufacturing known products or a substance. Patent term, so that is 20 years from the date of filing of the patent application. And in a certain cases like pharmaceutical patent, term of the patent can be extended by up to 5 years. So in that case, a total a patent life that can go up to a 25 years, but that will be subject to payment of a requisite of fees. Compulsory licensing, that is very important. A patent act will provide for a compulsory licensing of a patented invention in a certain circumstances, like when a patent owner fails to manufacture the patented product in India, or when the product is not available to the public at a reasonable price. So whenever actually a government sees the public interest is not protected. We have seen in India how actually government forced to sell the COVID 2019 vaccination at a reasonable price. So that we have seen. So that was to protect the interest of the consumer at large, or to make the patented product available to the public at a reasonable price. So that is the criteria. And compulsory licensing provision, these are intended to ensure essential medicine and other products are available to the public at affordable price. So that is ultimately. And the patent infringement, so we discussed about that. So Patent Act will provide for a civil and criminal remedy for a protect infringement. Provisions are there, but as we all are aware, how actually the getting a justice in India or elsewhere in the world, that is a long drawn process. So provision may be there, but ultimately what is important to get the justice at a shortest possible time. We all know about the pendency of cases in the courts across the India or across the world. So Patent Act will provide for a civil or criminal remedy for a patent infringement, and patent owner can file a suit or infringement in a court of law and seek damages, injunctions, or other remedies. So criminal sanction may also be imposed in a certain cases of patent infringement. Working of patent. So Patent Act requires that patent must work the patented invention. Patentee must work the patented invention in India within 3 years of the grant of the patent. So I have actually got a patent for a novel product, and after getting that, I am not taking any action for its commercial production, and I am preventing others also to have that product which is in the consumer interest. So for that, this provision is very important. So patentee must work the patented invention years of the grant of the patent or 4 years from the date of filing of the patent application. And this is very important, a patent cooperation treaty. So India is signatory to PCT, which allows inventor to file a single international patent application that is recognized by all member countries. So what is actually this PCT, a patent cooperation treaty? So I have highlighted that in a brief. We have less time, so we will not go into a detail of this. What I will do, I will try to actually send this PPT through organization of this event. So you may go through that about brief information of the PCT or a patent cooperation treaty. Around 150 countries they are a signatory to this global patent cooperation treaty. So this is the examination process under Indian Patent Act. In a brief, you may go through that. So it will start with the filing of patent application. Then a formality check will be undertaken by the patent office, and then it will be published in the official general patent office general, which is published on a weekly basis. I highlighted that, and then actually the patent applicant, they actually make a formal examination request to the patent office to initiate the examination process, and certain timelines are prescribed for that. Consequent to which examination of that application will be undertaken by the patent application, and after that, first examination report will be issued by the patent office, and whatever observations are made in that first examination report, so applicant will file actually a response to that first examination report, and if everything is fine, then finally the patent rights will be granted. So this is the examination process in a brief, and we discussed about the means opposition to the patent application by the affected party. So this will highlight the pre-grant, post-grant opposition mechanism under Indian patent law. So pre-grant opposition, so provisions are under section 25 of the Patent Act, and any person can file a pre-grant opposition against a patent application within 6 months of its publication. Even if there is no pre-grant opposition, so even post-grant, there are provision for post-grant opposition also. So once actually a patent rights are granted, but even after that, if some person from the public at large, if they feel they are affected, so there are provision relating to filing of opposition post grant. So provisions of that is covered under subsection 2 of section 20, 1 year from the grant of the patent. So that is about pre-grant and post-grant. And these are actually a provision relating to safeguards in the patent law. So compulsory license to ensure availability of drugs at reasonable prices, provision to deal with public health emergency, and revocation of patent in public interest, and also on a security consideration. So these are the safeguards. So how the process of compulsory licensing under Indian Patent Act works. So a provision related to that is part in section 84 of the Indian Patent Act. So that I have tried to highlight in a brief. So compulsory licensing provision. And now we will touch upon a certain important aspect. So price versus value. You all know in evaluation, actually, price and value, these are a very important consideration. So price is what we pay, and value what we get. So that is the brief. and means the price of a patent that denote the monetary exchange between willing buyer and a willing seller, and that will represent the amount for which the patent would trade in the market, and that will be determined by the buyer is willing to pay. So that is price, and a value that is means that will signify the potential future economic benefit to the owner or authorized user, and a future economic gain. So that will represent the anticipated benefit which may actually exceed the price paid, incorporating additional costs like time, transaction, and opportunity cost. So that is brief about price versus value. Very important in a valuation estimation. We understand the exact difference of price and a value. Very important. So in all valuation, there are a certain factor, whether we do valuation in India or in USA or any of the European country or any of the African country, Asian country, or whether we do valuation of a tangible asset, intangible asset, intellectual property right, patent, certain factors are common. So these are related to patent valuation also. Standard of value, premise of value, valuation approach, valuation method, technological and market dynamics, legal consideration, market demand and competition, and commercialization potential. So all these factors that will influence the value of a patent. IVS defined basis of value, international valuation standard. So as we all are aware, IVS divided into two parts: general standard and asset standard. General standard applicable to all type of valuation assignment. So we get information about standard of value or basis of value in IVS 104, and basis of value very important in evaluation that act as the foundation of entire evaluation estimation. We all know about the importance of foundation structure in a building. Same way in evaluation estimation, the basis of value that act as the foundation. So if we elect incorrect basis of value, probably our evaluation estimate will not be correct. So very important to understand what is the meaning of market value, market trend, equitable value, investment value, synergistic value, liquidation value, and these are actually IBS defined basis of value. So these are actually highlighted in IBS, and a meaning of that is also provided. Apart from that, there are other basis of value like a fair value as per IFRS or Indian accounting standard. Then a fair market value, so that is OECD, Organization of Economic Cooperation and Development, and they have provided fair market value, which is recognized by the court of law across the world. And then we have the fair market value by US IRS, Internal Revenue Service. You all may be aware about that. IRS is nothing but Income Tax Department of the USA, and a fair value. That is so very important. You will find value everywhere: fair value, fair market value, then market value, investment value, synergistic value, liquidation value. Very important to actually have the deep knowledge of each of these basis of value. Now, valuation approaches. Actually, as we all are aware, worldwide for all valuation assignment, there are three approaches to valuation: market, income, and cost approach. Market approach or a relative approach, income approach or absolute approach, and asset approach or cost approach. So these three approaches. These are based on the fundamental economic principle which we learned in economics during our college days or our professional study or our school days. So nothing new. What valuation we are doing, these are dependent on the knowledge which we acquired during our student age. This economic principle you must have come about a price equilibrium theory, anticipation of benefit, and a theory of substitution. So what is price equilibrium? So that refers to the idea that price of an asset or good that is determined by the forces of supply and demand in the market. So a valuation method, that is nothing but your market approach, relative approach to valuation, that are based on this principle, like market, that will aim to estimate the fair market value of an asset based on how similar assets are appraised in the market. Anticipation of benefit, so that is nothing but our income approach. For a DCF, ultimately assets are resources for a future economic benefit. What benefits we anticipate, based on that we derive the value of that asset or that business or that enterprise. Anticipation of benefit, that refers to idea that asset is valuable because it can generate the future cash flow benefit. So valuation method that are based on this principle, like a DCF, that will make to attempt to estimate the present value of an asset future cash flow. And a theory of substitution, so that refers to the idea that asset is worth no more than cost of obtaining a substitute asset, and that will provide the same benefit. So these are the three approaches which we need to cover in evaluation of a patent. Mainly, as we all are aware, the patent is intangible, and intangible valuation, mainly it is done through the income approach. But in cases where a patent is licensed, so in that case, we may take the comparable previous transaction detail and arrive at the value. So the income approach, as we all are aware, under IBS 210, which is related to intangible asset, we have five methods which are recognized: with and without method, or the relief from a royalty method, or the multi-period earning method, or we have the distributor method, or we have the greenfield method. So one of that will be applicable to the valuation of patent under the income approach. And these are the consideration which actually we need to take. The valuation of patent, that we will understand, that is a complex process, and that will depend on these factors, like what will be the market demand, how is the competitive landscape, technology strength, potential revenue, legal landscape, and time remaining on the patent, what is the economic life of the product. So these are the prerequisite of valuation. Actually we have less time, we will not go into a further detail of that, how to do under a cost approach, how to do under the market approach, how to do under the income approach. So that in a brief I have highlighted. And with that, actually, I will end, because we have actually less time, and we need to allocate certain time for questions also. So I again thank actually each one of you for your attention throughout this session. And I sincerely thank to the organizer of this particular session for giving me this valuable opportunity of sharing my knowledge with each one of you. And I wish you all the best for a new year. And before we end, so if you have any questions, we will take certain questions. So, madam, you can go ahead with the questions, if any, from the participants.
Thank you so much, sir, for such an enlightening session. Yes, we do have a lot of questions. So the first question is, as mentioned that valuation of intangibles are not part of balance sheet, what is basis adopted for quantifying these?
So a measurement, actually, we cannot generalize that process. That will depend upon the ground reality. Supposing if we take example, a brand value. So brand value, that is not reflected on the financial statement. So there are a certain consideration which we need to take to arrive at the brand value. So in that reference, I actually highlighted, if you visit the website of Brand Finance PLC, in their publication, they have given the method through which they have arrived the value of a brand. So that is just one example. And actually, we have less time, so we will not go into detail. But I gave you a fair idea how we can measure the value of those intangible, which is not part of the financial statement.
Thank you so much. So we'll move forward with the next question. What will be the effect of latest artificial intelligence on valuation and originality in regards to intellectual property of intangible?
So I find this question very important. As we all are aware now, a machine is competing with man. Many of the jobs are taken over by the machine. So most of the processes, whether that is related to finance or audit or evaluation, that is now automated. But actually, a valuation is related to the judgment. So any valuer, because everything actually artificial intelligence may not provide assistance in making a judgment. Probably at a future date that may happen, but I am talking about the technology at present. So there, without the manual intervention, which is very vital, maybe actually process of valuation, that is computation or a valuation report, that may be automated, but that will be useless if there is no manual intervention is involved. There is no judgment from the valuer is involved. So in that reference, I would suggest you actually, this is the era where if you want to make a difference, you should have in-depth knowledge of the area in which you are dealing. So that is the only alternative. World is becoming more and more competitive. It was easy to compete with men, but now we have to compete with machine. So that will require your ability, entire skill set. So I hope that will give you the answer to your query.
Thank you so much, sir. So, moving forward with there are a lot of questions, but we won't be able to take all of them due to
Okay.
paucity of time. So, I will take a couple of questions more. So, the next question is, what are the potential costs associated with maintaining and enforcing the patent?
Patent means that I have highlighted in my PPT also. So that is through the relevant portion from the annual reports of the reputed companies in the world. So if I want to compete in the market, as we all are aware, market is highly competitive. And if I need to compete in the market, I need to offer some differentiation. Now that differentiation need to be protected. FMCG, you will find many companies who are operating, but each company, if they don't provide a certain differentiator to the consumer, they will not command the price premium. So very important to command the price premium in the market, you need to have certain differentiation, and that differentiation need to be protected by way of patent rights. So very important to have the patent right in that direction. So I hope that will reply to your query.
Yes, sir. Thank you so much. I will just take one last question. If patent is partly granted, means in one country, patent is granted. Part of this patent is in another country that is not granted. Then how to amortize the expense?
So actually, the I highlighted that PCT. So in a PCT, there is a provision. If you go through that PCT, a patent cooperation treaty, which is actually around 150 countries are signatory to that. So in that, there is a specific provision. If one country has granted the patent, so other country will not raise the objection unless there are a substantial ground involved. So, in all probability, if some patent is granted in India and if a patent application is filed in China, so all probability the patent rights will be granted. Now, I cannot say 100%, certain exception will be there, and that need to be dealt with based on the ground reality or a factual position of each case.
Thank you so much, sir. It was indeed an enriching session. And before I end the session with a formal vote of thanks, I would want to make a small announcement. Please, I request all the participants to fill the feedback form. The link is available on your webcast screen. Also, if you want to see all the past sessions that have been conducted by the Valuation Board, you can see them through the YouTube channel of ICAI. So you can visit and you can see all the past sessions that have been conducted. Thank you so much. We extend a sincere thanks to a distinguished speaker, CMA Yogesh Chatwani ji, for his valuable insights. Sir, it was indeed a great session, a great learning. Thank you for sharing details about valuation of patents and all the intricacies. It was an insightful session and we learned a lot. So we also would like to express a gratitude to our chairman, CA Hansraj Chuk sir, our vice chairperson, CA Preeti Paras Sabla ma'am, and the entire support team of ICAI for initiating and supporting this platform for the field of valuation and guiding us. Last but not the least, we would like to acknowledge and appreciate our audience for dedicating your valuable time and for your active participation even on a Sunday. We are eager to meet you in our upcoming sessions. Thank you so much. Have a great day ahead. Thank you.
Thank you once again.